Please be seated. Good afternoon. We have two cases on the docket today. Our first case is American Honda Motor Co. versus Briarwood Apartments. Both sides here and ready.
Yes, Your Honor.
Would the appellant like to save time for rebuttal?
Yes, Your Honor. 2 minutes, please.
And our second case on the docket is Booker versus the State of Texas. Are both sides here on that case? Thank you. We've given each side 15 minutes, so it'll be about 30 minutes or so before we get to you. We're ready when you are.
Thank you, Your Honor. Chief Justice Christopher, may it please the court. My name is Ryan Boucher. I represent the defendant appellant, American Honda Motor Company. Your Honors, this appeal arises from a product liability lawsuit involving a vehicle fire. Plaintiff's defect theory has evolved throughout the case, but its ultimate theory was that 2 loose wires in the vehicle's fuse box causes fire. Now, it's undisputed that this fire occurred at approximately 3 a.m. after the vehicle had been parked and turned completely off for almost 10 hours. This case should not have proceeded past my client's motions for summary judgment and Daubert motions, but it nonetheless proceeded to a jury trial and resulted in a quintessential trial by ambush and an unsupported jury verdict in plaintiff's favor. I'm of course happy to answer any questions you may have, but there's 2 important points I want to make certain to address for the court as to why the jury's verdict should be reversed. First, the trial court abused its discretion because it allowed plaintiff's expert to provide undisclosed defect opinions for the very first time during trial. And second, the trial court, or the undisputed scientific evidence establishes that the expert's sole defect theory is not reliable as a matter of law. Turning to that first point, the trial court failed to comply with Rule 193.6 because it allowed plaintiff's fire cause and origin expert, Mr. Nestor Camara, to offer undisclosed opinions during trial, even though plaintiff altogether failed to carry its burden of establishing good cause or lack of unfair surprise. Now, stepping back, Camara's opinions were first disclosed in an expert report 8 months before trial. That report is in the appendix. It's the only report he issued in the case, and as the court will see, it contains no defect opinions. It does not even use the word defect.
Was the report admitted into evidence?
Admitted into, no, Your Honor, it was admitted for purposes of a Daubert motion, but not to the jury.
But he was deposed based on that report?
Yes, Your Honor. 4 months after issuing his report and 4 months before trial, American Honda took his deposition. At the conclusion of that deposition, Camara, for the first time, offered a conclusory opinion regarding a possible, not probable, possible manufacturing defect. But as I'll explain in a minute, he was not able to answer any follow-up questions regarding that possible defect. After his deposition, there was no supplement. In fact, in response to that Daubert motion that I mentioned, plaintiff represented to the court, Camara has already disclosed all his opinions 4 months ago in his deposition. That quickly changed on the last day of plaintiff's case in chief. Over American Honda's objections, Camara offered new and detailed defect opinions that were contrary to his deposition testimony.
And what did you present to the judge about it at the time?
The trial counsel objected, showed a copy of the deposition transcript, explained these, well, I should back up. A motion in limine was filed on this, which I know does not preserve anything, but was filed on this exact subject. There was extensive discussion pre-trial about this exact subject. Case proceeded.
The court granted the limine?
Court granted, and in fact, plaintiff agreed to the limine.
Okay.
As soon as it became clear he was going to offer new opinions, American Honda objected. The court overruled the objections. American Honda renewed and then got running objections. This exhibit provides a direct comparison between the deposition testimony on the left and the trial testimony on the right. And I'll quickly go through this, Your Honor, but in deposition, looking at that first one.
So it was the deposition in the record?
Yes, Your Honor.
In connection with?
In connection with a motion for summary judgment and a Daubert motion. And it was also shown to the trial judge. Yes, Your Honor. And then also post-trial motions.
Were all of these points shown to the trial judge that you have in your appendix?
It was discussed very extensively, Your Honor. All the the fact that he provided a very conclusory speculation, and then he became very detailed. Of course, we did not know exactly what he was going to say, so there couldn't be a side-by-side comparison until post-trial. But as you'll see in deposition, he spoke in terms of possibility. There had to be some sort of manufacturing defect. Just a loose connection could make it overheat. At trial, from the outset, he spoke in terms of certainties. When asked if he was able to identify a specific defect that caused the fire, he stated unequivocally yes within the power distribution box. That's the fuse box. Moving on to that second one. When asked if he had an opinion how the fuse box deviated from the specifications, he admitted in deposition, no, I can't tell you if it deviates. At trial, he did a complete 180. He referred to Plaintiff's Exhibit 34.147. It's a photograph that's in the appendix, and he identified a specific alleged deviation. This male part of the connector is not completely and properly inserted. He also testified in deposition, although he formulated an opinion as to the area of origin, not only did he not, but he said he could not formulate an opinion as to the point of origin.
So when he was being crossed, was he crossed with every single one of these deposition records that you have in your appendix?
I don't know if he was, at trial, I do not know if he was crossed on every single one, but yes, I mean, he was crossed on the fact that he said, I can't tell you how it deviates. I don't know where the loose connection is, and how he changed his opinion, Your Honor. At trial, he was somehow able to do what was impossible in deposition. He identified a specific point of origin. It's on the interior of this box, beneath the area. In the very last question of his deposition, he was asked if he could identify the location of the possible loose connection, and he answered, it's been destroyed, it's been changed from what it was, no. At trial, he provided the opposite testimony. This particular connector in the middle, that is the location. And more to the same point, Your Honor, in deposition, he confirmed he reviewed all the hundreds of photographs from all the experts in the case, but when asked, is there a photograph you can show us that depicts the deviation or point of origin? He said, I can't say that it was this particular contact, no. At trial, he completely reversed that. Referring to that same picture, he said, what I was able to do today is give you a photograph that shows you the exact location, a photograph that shows you exactly where it was. And then finally, relevant to all those points, at the end of his deposition, he was asked if he covered all of his opinions. He unequivocally answered yes. At trial, he expressly admitted to counsel in the trial court that he formulated all these new opinions in the right-hand column, quote, a long time ago. But the first time I relayed it to you was today. Your Honor, he did not change minor details. These are material changes. As I mentioned, he did a complete 180 on his answers from deposition. And
well, the trial judge said, well, you should just cross-examine him. And so I'm trying to figure out whether you cross-examined him with all of these points.
He was cross-examined, but I think the more important point, Your Honor, is the Texas Supreme Court, for example, in E.F. Hutton versus Youngblood, and numerous intermediate courts of appeals have explained that cross-examination and the ability to impeach is not a basis for good cause or lack of unfair surprise, because the purpose of the disclosure rule would be subverted if the only remedy for a violation of 193.6 was an attempt to cross-examine or impeach without the benefit of preparation and sufficient time. And if there's any doubt as to that 180, all you have to do is look at the closing argument of the trial, specifically page 258 of the record. If plaintiff's counsel, if the trial court had not allowed all the undisclosed opinions, the ones in the right-hand column, plaintiff's counsel would not have been able to stand in front of that jury and argue, the photograph is proof positive. Here's the photograph right there, and that's why the fire started. It's that simple. We identified the defect, and they did not dispute it. Instead, plaintiff's counsel would have been stuck with the conclusory opinion and the unanswered questions in that left-hand column. He would have had to stand in front of the jury and argue, you know, Camara, he suspects there may be a loose connection, but number one, he doesn't know, he suspects there's one, but he can't tell you anything about the specifications because he hasn't reviewed them, and so he can't tell you what the deviation is. Number two, Despite inspecting the fuse box, jury, he can't tell you where that possible loose connection is. Number 3, although he reviewed hundreds of photographs, he can't show you a single one that shows you a deviation. And sorry, jury, he's not able to give you a point of origin. But plaintiff wasn't forced to give that closing argument because the court allowed the undisclosed opinions. And under Rule 193.6, exclusion is automatic. For that reason alone, the trial court abused its discretion and the jury verdict should be reversed. Turning to my second but equally important point, Your Honor, the undisputed evidence and even his own testimony shows that his whole liability theory is unreliable as a matter of law. Now, his theory is that a loose connection led to a glowing connection, which is just a wire that is so hot that it starts to glow. Let me try this right. And so the viability of that theory was dependent on the fact that the Honda CR-V had sufficient electrical current when turned off to start a glowing connection. Now the problem is he didn't know two critical pieces of information that were the foundation to that theory. Number 1, he didn't know how much electrical current was required to start a glowing connection. So he looked it up in a scientific resource entitled the Ignition Handbook. That resource told him it takes 4,000 to 6,000 milliamps of electricity to start a glowing connection in that wire that he showed in the photograph at trial. Number 2, and maybe more importantly,
And he admitted to that, and there was no contrary evidence.
there was no contrary, that came from him. He looked that piece of information up because he didn't know it. Second, he did not know, even as he stood on the stand at trial, the amount of electrical current in the CR-V when it's turned off. He didn't make any effort to obtain or determine that information. He simply assumed that there was 4,000 to 6,000 milliamps. He assumed that because one of the 2 tests he performed was to determine, is there electricity in the fuse box? He determined there was. He didn't take the next step to determine how much is there. That is the definition of an analytical gap. Well, once he stepped down, the undisputed testimony from 2 separate witnesses established that there's only 10 milliamps of electricity in that CR-V fuse box when it's turned off. In other words, there's 3,990 milliamps less than the minimum required to start a glowing connection, to start a fire.
Well, can a loose connection increase the electricity?
I'm sorry, Your Honor, what is it?
Can the loose connection change that initial 10 to 20?
There is no evidence of that, no, Your Honor. It's simply...
I mean, is that his opinion, that the loose connection did that?
It's his opinion that it's referred to as a high resistance connection, and the only testimony in that is that a loose connection, a high resistance connection, requires 4,000 to 6,000 milliamps. And the only evidence as to the amount when it's turned off was the testimony that there's 10 milliamps, 0.25%.
Did he know whether or not there was current running through that wire where the loose connection was?
That is all he knew. He knew that there was current, he didn't know the amount.
Okay, so the high resistance connection does have current going through it when the engine's on.
So for example, when a vehicle is turned off, you need a little bit of power to turn on, your alarm. But all of that is to show that his whole theory was not even scientifically possible, much less probable. He just didn't know that as he stood on the stand. And I see my time is up, Your Honor.
Thank you.
Thank you.
May it please the court. My name is Byron Keeling. Along with Adam Boyles and McKenna Parker, I represent the appellee, the Briarwood Apartments. To paraphrase Sherlock Holmes, if you eliminate everything else, what's left must be the truth. The gold standard for fire investigations is NFPA 921, and it requires exactly that. It says that in a fire investigation, you use the process of elimination to work from the area of origin down to a specific cause. So let's set what we know with certainty. What we know with certainty is that everyone in this case, including Honda's expert, said that the fire began at a Honda CR-V. Eyewitness testimony and fire patterns established that the fire was under the hood. So once you've gotten to that point, we know that something happened in the engine compartment to have caused this fire. This was a brand new Honda CR-V. Brand new cars don't ordinarily burst into flames. So I'm going to take Honda's arguments in the order in which Honda presented them, but I want to begin with an argument that cuts through everything Honda's counsel said this morning, because the first place to begin is whether the circumstantial evidence is sufficient to support the jury's finding of a manufacturing defect. And it is. Under Texas law, expert testimony is not mandatory to establish a manufacturing defect. A manufacturing defect may be proven by circumstantial evidence. And where a product is new or almost new, a malfunction in that product may establish a manufacturing defect if circumstances are that the product ordinarily would not have malfunctioned in the absence of a manufacturing defect. That's the case here, and because the evidence supports that, the court need not even reach any issue about Mr. Camara's testimony. Honda says, well, this product wasn't really old. It was 6 months old. But courts have applied
So
the new
you're
product.
arguing that there's sufficient evidence without any expert testimony?
I am saying that
And
even...
what case are you relying on for that?
Oh, in part, I'm relying on Sean T. Meehan, but I'm also relying on the federal court opinions in Oldham and Shoney Service. Now,
But our courts, the 1st and the 14th, have said that expert opinions are required for manufacturing defect cases.
and the Texas Supreme Court has drawn a distinction that the court in Sean T. Meehan addressed at some length. What the Texas Supreme Court has pointed out is what is true, and no one's going to deny it, that normally, and in fact conclusively, you can't just stop at the idea that a product malfunctioned and therefore it was a manufacturing defect. That in itself is not enough, and that's what this court has held. That's what the Texas Supreme Court held in Ridgway and in Mendez. But in Ridgway and Mendez, the court also pointed out, look, we haven't decided one way or another whether Restatement Section 3 applies. We're not addressing that in Ridgway and in Mendez. If it does apply, it applies only in circumstances involving new or almost new products. And the courts in both cases discuss specific examples of cases that apply that new product inference. And since then, other courts have recognized that the new product inference will enable a finding of manufacturing defect under an and-plus scenario, if the circumstances are such that ordinarily you wouldn't expect to have a product defect in the absence of a manufacturing.
What constitutes a new product again? I mean, this was 6 months old.
A new product is often going to be a fact issue, but Texas courts have applied the new product inference even under circumstances where the product is 14 to 18 months old if it's lightly used. And in this
I mean, if your expert is correct, if his theory is correct, why wouldn't what was the explanation as to why the car wouldn't have caught fire when it was being driven around for 6 months?
The simple explanation for that is provided by the text of NFPA 921 itself. And that goes into Honda's Dauber argument, which kind of morphs with whether you're looking at Honda's opening brief or whether you're looking at its reply brief. But as NFPA 921 says on its face, when there is a loose connection, the loose connection can, over time, generate heat because it is a high resistance connection. Think of it as smoldering. In effect, that misaligned connection, and in this particular instance, the photo showed a misaligned female and male end. Where those aren't tightly connected, then under the pressure of a long drive, it may start to generate heat. But that heat doesn't spontaneously cause combustion. And in fact, NFPA 921 says that for certain electrified equipment, even after it's powered down for some period of time, that heat can continue to increase. And that increased heat can at some point become a glowing connection that is hot enough to incinerate other items around it and produce fire. And really, that is the only scenario that makes sense.
It
based upon-
increases the heat, or it does not decrease the heat?
It continues to increase the heat. And in fact, you'll find federal case law that discusses that specific scenario. We've cited that in our brief as well. So the new product inference, I submit, is enough to enable the jury here to have found a manufacturing defect. But certainly Mr. Kamara's testimony on top of that it is also sufficient evidence to support the jury's finding. So Honda complains that Mr. Kamara's testimony wasn't adequately disclosed. Honda necessarily must acknowledge, and does acknowledge, that it knew the substance of Mr. Kamara's testimony after Mr. Kamara's deposition. Mr. Kamara testified in his deposition exactly what I just said, that it had to be a loose connection somewhere in the fuse box that, because of high resistance heating, generated the initial spark that caused the fire. And in fact, in the deposition, Mr. Kamara went so far as to say, what we're looking for is a misaligned male and female connection. So the only thing really that Honda complains about, and again, I respectfully chide Honda a little bit for trying to impugn the entirety of Mr. Kamara's testimony, but as far as the disclosure issue, the only thing Honda really complains about is Mr. Kamara's testimony about his description of a photograph, PX 34.147, that shows exactly that, a misaligned female and male end in the remains of the fuse box in the fire. Now, at trial, Honda itself took the position that an expert's description of photographs is not expert testimony. You'll find that in the record at 3 CR 3591. And it's clear that the trial court, the Honorable Terry Jennings, relied exactly on that and continually pointed back to Honda. Look, you have yourself taken this position that it's fine for an expert to describe what's contained in a photograph. That, according to you, Honda, is fact testimony. It's not expert testimony and therefore need not be disclosed. But regardless, Justice Jennings also pointed out repeatedly that the case law, which Honda itself had cited to Justice Jennings, also says that an expert need not disclose new evidence that supports an already disclosed position. And what Mr. Kamara was testifying to in that photograph was something that supported his already disclosed opinion that a misaligned female and male end must have been the cause of the fire in the fuse box.
The oral argument exhibit makes it certainly seem like there wasn't proper disclosure. Do you have rebuttal answers from the deposition that would rebut the answers at trial?
There was certainly trial testimony as opposed to deposition testimony where Mr. Kamara explained what
Yeah, but that would be all new
found.
too. So my question is, do you have answers in the deposition that are more aligned with what he gave at trial than what is in this oral argument exhibit?
Now, the record is what it is. Certainly his deposition is part of the clerk's record, and his deposition points out that at the time of his deposition, he had not identified this photograph. There's no question about that. And again, the question for purposes of today is not whether I would have disclosed the photograph or Mr. Kamara's testimony about the photograph before trial. The testimony is simply an abuse of discretion standard. It's whether Justice Jennings abused his discretion in allowing the testimony
Well,
under these
that's
circumstances.
generally the rule for evidentiary purposes, but under Rule 193.6, it's a mandatory exclusion.
It is a mandatory
So
exclusion.
there has to be a showing of the lack of unfair surprise or.
Right.
Okay.
And those findings may be implied from the record, and certainly that was what Justice Jennings was relying on when he said, look, you yourself have taken the position that his testimony about photographs is not expert testimony. Look, you got plenty of time. Your expert's here in the courtroom. I'm going to let you examine him so that you can determine for yourself whether his testimony actually matches up with what the photograph shows. You've got time overnight. In fact, later he said if you needed an extension, I would have given that to you. We could have taken a continuance, but you didn't ask for one. All of those are factors that support an implied finding of good faith or lack of unfair prejudice. Now, as far as the Daubert issue goes, let's be clear about the chronology. In Honda's opening brief, Honda says, well, here's the problem. The problem is that a car in idle can't generate sufficient heat to cause a glowing connection. But Mr. Kamara said that was never his theory. And it was apparent from Mr. Kamara's trial testimony and his deposition as well. What he was saying was that there was a loose connection. That connection is a high resistance connection that generates heat, and the heat existed when the car was put in park because there was still fuel, there was still current.
I'm trying to understand this. If a loose connection existed at the time of manufacturing, why does it take 6 months for it suddenly to cause a fire?
Almost entirely the fact that it was taken on a 2,000-mile road trip that it had never previously endured. The testimony was that this was a car that was largely parked in a garage, was taken only on small trips, and then the Tao family took a trip from South Dakota down to Texas, and that's the kind of long trip that would generate heat under those
The day
circumstances.
before it was parked?
The day before.
The day it was parked?
Right.
Where is that in the record?
Oh, it's, I can submit that.
I mean, I know the
specific
trip, but the idea that a 2,000-mile trip gets a car hotter than a 20-mile trip.
Oh, that's in Mr. Kamara's testimony, and I can provide the court with those record references.
Did Mr. Kamara provide or conduct any testing of this theory on an exemplar fuse box to show that a loose connection like this, when you pass current through it, would ignite?
He didn't do that kind of testing. He cited literature which has done that kind of testing. What he did do was secure an exemplar and x-ray the exemplar so that he knew what the components were. And that was one of Honda's criticisms. Honda says, well, he never looked at the specifications. But he did get an exemplar. He x-rayed it multiple times. Honda, in its brief, refers to the first x-ray, but ignores the rest of the testimony where Mr. Kamara explained he did multiple x-rays to be familiar with the components. Plus, he went to Chilton's, a service that provides manuals to mechanics so that he could get information about the components in the fuse box. And you'll find that in the supplemental clerk's record at 312 through 317.
And do you dispute or agree with your opponent's chart about the amount of amperage that it takes to form a glowing connection versus what's going through the fuse box when the car is idle?
And I see I'm out of time. May I answer that
Please,
question?
yeah.
Okay. So that's a new argument that comes up for the first time in the reply brief. And that argument, again, shifts the chronology. So now what Honda is saying is, well, there had to be a glowing connection when it was parked. So this fire surely would have started long before the overnight period in which the car was parked. But again, that just misreads Mr. Kamara's testimony. He never said that there was a glowing connection at the time it was parked. There was high resistance heating, to be sure. But under NFP 921, high resistance heating can continue to build up even after a car is turned off. NFP 921 has.
Is there any studies that say it can continue to heat up from, 10 to 4,000?
There's no studies in this record, but again, that's on the face of NFPA 921. There's a whole chapter on motor vehicle fires, chapter 22. And chapter 22 says, look, one of the things we look for is high resistance heating, and that heating can occur and cause fire in electrified products even after a car's turned off. So, thank you. We respectfully ask that the court affirm the trial.
Thank you.
Your Honor, there are 3 points I want to quickly address. The first, citation to the record about what Honda argued. That's incorrect. They did not at any point argue that an expert can testify to a photo. It was their corporate representative who provided testimony regarding the TIM amp milliamps. Plaintiff did not object. They did not appeal that point, so the goose gander argument does not apply. Second, I think acknowledging that the only evidence in the record is scientific analysis establishes that a glowing connection cannot start in a vehicle that's turned off after 10 hours. They pivoted on appeal, and there's now a new theory on appeal. I mentioned that these theories have evolved, and now it is that it reached sufficient heat when it traveled across the country to be able to start a glowing connection. The second test that Camara actually did perform was to determine how hot a glowing connection is, and he determined it's 2100 to 2700 degrees Fahrenheit. To put that in perspective, water boils at 200. Metal melts at 1200 degrees. So there's no way that it could have reached that temperature, been parked and sat there for hours. His testing actually showed that at that level of heat, those same exact components set on fire within seconds, and they remain burning and do not extinguish. Turning to circumstantial evidence, they rely upon 2 things. One, testimony from the fire department that they've corrected in a letter, they misunderstood the testimony. And 2, that the vehicle was brand new. Not only did was it 7 months old, 3,500 miles, had driven from South Dakota to Texas, but Camara's own report, page 22778, shows that a month before the first owner purchased it, it underwent some repair or servicing, and we don't know what that was. By definition, that is not a new vehicle. And their circumstantial evidence testimony is directly contrary to Texas Supreme Court's opinions from 2004 to present day. They haven't found that sufficient in any case. I see I'm out of time. Thank you for your time. Honda respectfully requests that the verdict be reversed and judgment rendered in its favor. Thank you.
Thank you. All right, the case of Honda Motor Company versus Briarwood Apartments is submitted, and you all are excused. Come on up. And would the appellant like to save time for rebuttal?
Yes, please. 4 minutes.
We're ready when you are. I didn't want to rush you.
Oh, no, thank you. Chief Justice Christopher, may it please the court. I've got 10 minutes or 11, so I'm going to jump right in. And reading the record in this case, along with the motion for new trial transcript, should scare you. And I did say scary. because we are all familiar with the Sixth Amendment right to counsel. And it may not be a right to perfect counsel, but it's a right to reasonably effective counsel. And while there is a presumption that trial counsel had a sound trial strategy, I can assure you that in this case, there was no sound trial strategy. And one of the big things in this case that is different than a lot of ineffective assistance of counsel cases that I've read is we have so many issues throughout the trial. Because tunnel vision, when we're talking about trial strategy, tunnel vision is not trial strategy. And by tunnel vision, I mean the inability of Mr. Powell to go outside of the language of the indictment. You will see all throughout the record when it comes to how is Mr. Booker charged, put up the indictment, put up the indictment, let's read the language. But in the jury charge, when it comes to the law of parties, it's like it flies over his head. And in the motion for new trial, he actually says, when he's asked about it, you never get there, you never get there. But the problem is you do get there. And that's a way that he can be charged. And so tunnel vision on just the language of the indictment cannot be a trial strategy. Misunderstanding the law is not a trial strategy. And by that, I'm referencing, again, the law of parties. Sudden passion that I'll talk about. Parole and what parole means. He had no clue in his punishment argument how to describe parole or what it is or how you can relay that to a jury. That is not a trial strategy. An idea, having an idea is not a trial strategy. It can become one if you can build it up, if you can develop it, but alone having an idea like Mr. Powell had when he made up his self-defense without ever talking to his client, and you see that in the motion for new trial transcript. When he's asked about, well, did Mr. Booker actually tell you about the gun? Did Mr. Booker tell you that he heard about the gun? And he just kept dodging the questions. And then finally it was like, hey, can we come back to this? This is kind of important. And finally he's like, yeah, no, he never actually said it. I mean, I just figured, I know he said it, I just know he said it, or heard it. I know he did. But did he tell you? No. Making up a defensive strategy is not a trial strategy. Thinking opening statement helps establish the self-defense is not a trial strategy. And in the motion for new trial, Mr. Powell even says, when Mr. Nelson said, did you have anything else that you presented other than Taylor Requinez's testimony to support your self-defense? And he says, well, obviously you're not aware of my opening statement. And Mr. Nelson said, well, I'm aware of the opening statement, I read it, but I'm asking you about evidence. An opening statement's not evidence. But to Mr. Powell, he said himself, he thought that's what helped him get there on the self-defense. Not preparing a witness is not a trial strategy. And I understand that in certain cases, if that's our only issue for ineffective assistance of counsel, it can be a trial strategy. Not preparing, you don't want to over prepare, you want the testimony to be raw, to be real, to be persuasive. I get that. But the problem in this case is not only did he not prepare his witness, he did not watch him testify in his own trial. The testimony about that was a little confusing, but it got cleared up in the motion for new trial transcript. Mr. Powell never saw that portion of his trial. Mr. Powell never requested the transcript of his testimony at his own trial. So Mr. Powell, not only did he not prepare his witness, the one witness he was going to use for that self-defense strategy, he didn't even prepare himself to be able to question him because he had no idea how he would be impeached with his own prior testimony. That is not a trial strategy. Completely missing a mechanism to reduce a murder charge from a first degree to a second degree is not a trial strategy. Sudden passion definitely applies in this case. And Mr. Powell's, you never get there, you never get there, you never get there. In the motion for new trial
Well, there was an
transcript,
hour between the alleged passionate, inspiring event and this altercation.
Yes, absolutely.
Case law says that's too long to be sudden passion.
Well, I think the case law and the argument can be made that it can't be before you're cooling off, your cool reflection. So it's going to be fact specific. We've even got a local case here that's mentioned in the motion for new trial, just as an example. Clara Harris sat there for a long time. But in this particular case, the whole thing that got this case started was an emotional, reactional jab by someone who had sexually molested a young girl. She hadn't seen him in, I think it was 11 years. And then she sees him, and he makes a little snide comment about her younger sister and, hey, I've seen her lately, or I've seen pictures of her lately, and she's looking good. Well, that triggers Alexis May, who's Mr. Booker's sister, to do her spiral, her emotional spiral. She then goes to Mr. Booker to relay, first she's distraught, she's looking for her best friend. She tells Mr. Booker this is his first chance to hear about this. He hasn't heard about it yet. Protective older brother, and yeah, I get it. He's a hothead. I mean, that came out quite well in the transcript. But he's still the older brother. And whether he's playing pool or being consoled, we're in an emotional situation. And one thing, and it's different, but it's kind of the same. The whole concept of mama bear, right? We hear this all the time. They make shirts that say mama bear on them. I know I have one. But it's this protective nature. It's human nature to want to protect those you love. If I hear someone is mean to my daughter, the first thing I'm like, what? Who said what? Who did what? Don't make me mad. Because my nature is to protect. Now put that with Mr. Booker. His nature is to protect. That's his little sister. There are many things you don't want to happen to your loved ones, but something that's so important is sexual molestation. That's one of those things, it never goes away. The damage from that is life lasting, and that's what we're dealing with. So I do understand the time, the 1 hour, the 6 minutes. It is a long time, but when you look at it in the whole picture, you are allowed to stew on something. You're allowed to continue to be upset and thinking without projecting it to everyone. And in this particular case, there's evidence too that Crystal Figueroa started.
But if he had asked for it and the judge had said no, you wouldn't be in a position to say, based on case law, that that was wrong.
If he had asked for it and the judge said no.
Right.
Possibly. But, really, I would still argue it. If he asked for it and was said no, because the standard is relatively low for that jury instruction. The evidence, there just has to be some evidence, whether it's weak, it's strong, it's not even, it doesn't matter if the trial court thinks it's really credible, just some evidence.
But again, then we get to the case law that says you're not entitled to it if it's been an hour. So.
Well, I think in this particular case, watching him, and then Mr. Sanders leaves after yet that interaction with Crystal, and Mr. Sanders is mouthing off. And so then you have Mr. Booker, who still is stewing in this, my sister was just molested by this man, here he is, now he's running his mouth again. I think you're still in that. I don't think that went away in the hour. But because I believe the burden is relatively low to ask for and get that instruction, the sudden passion, I would still stand here and say that in this particular case, there's a reasonable likelihood that the jury would believe it, because you're taking everything together for that instruction, for them to decide. And the prejudice of not getting it, if there's that reasonable likelihood, you're looking at a first-degree felony to a second-degree felony. That's 5 to 99 to 2 to 20, and we have Mr. Booker with 29 years. So I do think that if he asked for it and is told no, we still have an issue, but our issue in this case is he didn't even ask for it. And I think it was in Hart, that's a relatively recent case from this court, that says, and this is where the trial court offers to give the sudden passion, and defense counsel's like, no, I don't think it applies here, no thank you. And the trial court's like, excuse me, I'm offering sudden passion. He's like, no, I don't think it applies here. In this case, It says, because reasoning for rejecting the instruction offered by the court was erroneous, it cannot form the basis of a sound trial strategy. And I think for Mr. Powell, his lack of understanding of sudden passion was erroneous. His inability to even look into it was erroneous. And the thing about sudden passion is it's in the penal code. What's the first thing you do when you have a client charged with a criminal offense, especially if you're going to trial? You read the statute he's charged under. The first thing you see in the murder statute is sudden passion. It is at the top in the definitions. And then at the end, then it goes into murder. And then at the end, it's the significance that it reduces that punishment level. So here, we don't have someone asking for it and not getting it. We have just a complete disregard to it altogether. And the prejudice for that is substantial in this case. And I do understand, Justice Weiss, you wrote a dissent in Hart. And I completely understand that one of your concerns is taking away the discretion that seasoned criminal defense attorneys have to make their trial strategies. But there was also something different in this case, and that's what the Court of Criminal Appeals noted when they sent it back, was in Hart, there is no motion for new trial, and there is no testimony, and there is no allowance of that attorney to actually explain himself. And in this case, we have that. We have all of that on the record. We have Mr. Powell talking about, he talked in circles about his strategies. And when I go back to the tunnel vision, I'll sit down, he is very into, no, didn't apply, no, didn't apply. But he never said anything like, I actually looked at it and thought it through, which again is also distinguishable from Hart, where he did look at it.
Thank you.
Good afternoon. May it please the court, my name is Scott Talafero. I'm a prosecutor with the Galveston County District Attorney's Office. It sounded to me that counsel just a minute ago was asking this court to consider the credibility of trial counsel's testimony during the new trial hearing. The I think most significant thing to remember about that particular claim is that it's already been addressed by the trial court. So I think what's needed here is implied findings. The trial court, of course, didn't issue express findings, so implied findings are warranted. In particular, there should be, I would submit, an implied finding that that Mr. Booker did not rebut the strong presumption that his counsel's conduct fell within the wide range of reasonable professional assistance. The trial court had, I think, good reason to believe the testimony of trial counsel. Mr. Powell did testify that sudden passion would never fit, and that's because there was no sudden passion. Now, one thing to remember is that Mr. Powell had met with Mr. Booker multiple times. He had also met with the co-defendants multiple times. Of course, Mr. Powell was present throughout the trial and was familiar with all the evidence that was admitted at trial. So it makes sense that the counsel's testimony would be found credible. And so I would ask the court to also make an implicit finding that Mr. Powell was found to be credible by the trial court. And there were a number of reasons why Mr. Powell might say that the sudden passion doesn't fit. First of all, there was no direct provocation from the deceased, as the court knows. The only arguable provocation here was the fact that the victim allegedly made a statement to the defendant's sister, who then told him about it, and that caused him to be upset. Also, there's a reason to believe that Mr. Powell would have concluded that the defendant didn't act under, as the court just pointed out, under the immediate influence of a sudden passion. There is a reference in the record to an hour and 6 minute gap. I would point the court specifically to the fact that there were 19, if you look at State's Exhibit 12, which is the video showing the table where everybody was seated, there was a 19-minute gap, or rather the defendant was seated the appellant was seated at his table for 19 minutes before he actually left the bar. And during that 19 minutes, the victim was nowhere to be seen in that video. There was no contact reflected in that video between the defendant and the victim, so that if there was some provocation, it did not occur at that time. And I think most importantly, counsel could reasonably have surmised that under the facts as he knew them, the evidence would not have shown that the appellant lacked the capacity for cool reflection. There's been reference to the hug, that a woman was hugging appellant at the table, and that I think there's testimony from a detective that the hug reflected that the woman was consoling the appellant. In fact, it turns out that the woman who was hugging the appellant was his sister, the woman who reportedly had been sexually abused by the victim, a decade or so earlier. So, I'm not criticizing the detective for making that mistake, but the fact is, trial counsel knew what the situation was, and if there was a hug, Mr. Powell may have concluded that there was something more going on or something different going on and that she was consoling him. It may have been the other way around. But more to the point, if you watch the video and you see what happens after that, there are 13 minutes between the time that hug ends and the time when the appellant exits. And what you see is that the appellant is bouncing his head to music. He's hugging his girlfriend, and there's actually a point in time where, and they're very close. He's kind of got his arm around her, and there's a point where she sort of playfully slaps him. She playfully pushes his face, and he in return does a similar thing, not in any kind of aggressive way. He playfully does something like that, kind of a pretend slap toward her. Nothing the least bit aggressive. And then after all this happens, the two of them, the appellant and his girlfriend are sitting there looking at her phone for a long time, for about 7 minutes. So he's not the appellant's not pounding on the table. He's not marching the floor. He's not doing anything that would suggest that he does not have the capacity for cool reflection. And counsel may reasonably have taken that into account when asserting during the new trial hearing that there's no sudden passion there. On the question of prejudice, I'd also point out to the court that the issue here is not whether the maximum sentence could have been 20 years if counsel had made the argument and if the jury had bought it. Rather, the question is whether, if that instruction had been given, whether the jury would have found in the defendant's favor on the sudden passion issue. And that's made clear by the Wooten case, which I believe is cited in the brief. Next, I'd like to shift over to the first point of error. I don't think that was addressed today by counsel. There was a lot of talk during the at trial and also in the briefs about this video, State's Exhibit 14, video of the parking lot. You've probably seen it there. Really, there are three parts of that video, basically. There's the first part where it shows appellant running from the bar out to the car. He turns, goes around the back of the car, and then engages with the victim. There's a second part, and I think this is the part of the video that's at issue. The second part of the video doesn't really show what's going on at that particular point in time. And then there's a third part that shows what happens later, showing other people doing various different things in the parking lot. Now, it appears to me that that appellant is not challenging all three of those portions of, and I don't mean challenging in the sense of admissibility, but challenging in the sense that the claim is that the second part doesn't have probative value. It's not probative of what happened with the defendant, what the appellant did at that point in time. Well, what I would point out is that the first part of the video, the part that shows appellant running from the bar to the car, around the car, and engaging with the victim, that part of the video apparently appellant acknowledges is probative. And I direct the court to page 42 of appellant's brief, where it's conceded that the brief says, here it was undisputed that something caused him to run and catch up with Sanders and block him from entering his car. So that's not an issue. Now, the reason I'm saying all this is that the state's position is that fact alone, that portion of the video, coupled with the other evidence, is sufficient to justify to support the verdict. Even if the court totally disregards the second part of the video, everything else is sufficient even without that. I mean, we know that appellant had a motive. He was told by his sister that she had been sexually abused. He was mad, according to the defense. He was mad to the degree that he acted out of sudden passion. He was in a position to know that an assault on the victim would likely occur that night. I think counsel mentioned that one of the bar employees testified that Crystal Figueroa and Antonio Figueroa, that is the woman with the baseball cap and the man in the blue shirt and the medallion, they were both screaming across the bar about the old man and about how he was a child molester, and screaming they can go out to the parking lot. If anybody wants to defend them, they can. So the defendant appellant was present when all that occurred. He put his hood up when he was exiting in an apparent attempt to conceal his identity. Also, and I think this is pretty significant, he was clearly aware that three of his co-defendants he had a reason to know that the three of his co-defendants were going to beat down, frankly, this 65-year-old man. The appellant left the bar after those three individuals. There were two individuals, co-defendants, who were walking right behind the victim. Then there was the third one who literally ran out of the bar, started running before he left the bar. The appellant was in a position to see all that, so he had a reason to believe that at some point after midnight at a bar, when three people leave, follow somebody out under the circumstances, that there was a likelihood that that victim was going to be attacked. And the appellant in this situation actually played a bit of a leadership role. He when he ran out, he passed all three of his co-defendants, and he actually reached the victim before anybody else did. He was the first person to reach, and so in a way that was a bit of a leadership role. Now, so the state's position is that on the basis of that evidence alone, if the court doesn't even consider the video part, the second part of the video, and doesn't even consider the testimony about the second part of the video, the testimony of the two detectives that appellant threw the victim to the ground, that the evidence is still legally sufficient. Now, in terms of the second part of the video, I'd point out that this is really a question for the jury in terms of whether that's probative or not. The jury could probably have considered that evidence. The video was admitted for all purposes. The admission is not being challenged on appeal. There's no claim that it should have been redacted. Also, the jury could reasonably have relied upon the testimony of the detectives about that second part of the video. That was competent evidence. And the jury could well have found that testimony to be credible. Those detectives, like the jury itself, had reviewed the video multiple times, had reviewed it at different speeds, and they testified about what happened. And of course, their testimony was supported by the video itself, which the jury had seen. In addition to the video, there's a scientific evidence relating to the blood found on the floor behind the driver's seat in the vehicle. The vehicle that appellant and two other co-defendants left with. The state's not putting a whole lot of weight on that. The simple fact, though, is that what it does show is that appellant was in the presence of the victim after the victim started bleeding. While whether his blood was on the ground or whether his blood was spattered onto, we don't know, but somehow or another the appellant had the victim's blood on his shoes. And of course, there's circumstantial evidence that the fact that appellant fled from the scene, the fact that appellant lied to the police during his interview with the police. He stated adamantly that he was not there. He was in Louisiana at the time. He even said that his phone was in Louisiana at the time. And of course, both those things were untrue.
Can you briefly address the self-defense issue?
Yes, Your Honor. Well, there are two things that the evidence must show in order for a defendant to be entitled to self-defense. One is that there has to be evidence that reflects the admission by the defendant that he committed any otherwise unlawful conduct. And that admission has to, and it doesn't have to be a direct admission, it can be testimony from some other witness, but the admission has to address every element of the offense, including the culpable mental state. And that's the seminal case for that is the Shaw opinion out of the Court of Criminal Appeals, 243 Southwest 3rd, 647. That case isn't cited in the briefs, but it is referenced in the Jordan case, which is cited. And in fact, this court actually applied Shaw more recently in 2023 in its Olmos opinion, OLMOS 693 Southwest 3rd, 474. And in this case, there's been no such admission. There's no express admission. As I said, the defendant appellant actually denied that he committed the offense or engaged in that conduct. And likewise, there's no basis for any inference. In the brief, appellant says that it's undisputed that it was undisputed that the events that are depicted in the first part of the video occurred, but that's not evidence. That's not testimony. That's not evidence. That simply doesn't count. The second thing that's required.
I'm sorry, I didn't understand that argument.
Yes.
The video is obviously evidence.
Oh, correct. The video is evidence, but there's no admission by. There has to be an actual admission by the defendant, by the appellant, that he engaged in that conduct, and that he interposes a defense as a justification for that conduct. That simply hasn't happened. Merely, imagine a situation, a case where the defense team just sits silent and all the evidence from the state comes in. That's not sufficient. In fact, some of the case law, in fact, the Olmos opinion by this court actually says that a defensive instruction is only appropriate when the defendant's defensive evidence essentially admits to every element of the offense, including the culpable mental state. So there has to be something more than the state's evidence, is what I'm suggesting to the court. The second thing that must, well, I see that I'm out of time.
Thank you.
Thank you.
So I'll touch briefly also on the self-defense. There is the testimony, well, it's with the video and the self-defense because they're intertwined, obviously. We have a video of Mr. Booker running out there, and he does, as he just said, he runs past everybody and he knocks Mr. Sanders to the ground. And what happens from there on the video is you can see Requenes, and I believe it was Gomez, and the testimony says the two guys in the white shirts, they're the ones beating and kicking, and you don't see Mr. Booker. Whatever he's doing, you can't see him because he's off the screen. And even in the testimony with,
well, but
pardon?
He had to get the benefit of self-defense, didn't he have to essentially admit, didn't he have to admit the elements of the offense against him first?
So this is where it gets a little, a little fuzzy, because we have kind of that split argument, right, where it's Mr. Pell's trial strategy was self-defense, 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 and you're not going to get anywhere else other than self-defense. We're going to get this not guilty. He even says that motion for new trial. I thought we could get a not guilty, but he doesn't establish it like he should. And so in our ineffective assistance of counsel claim, we're like, he's so into this self-defense, and he's got Requenes, and he thinks he has the gun, and then there is testimony that Mr. Booker knocks him down, and then I'm unfortunately not disagreeing with you that
right.
Part of
that's the basis for your ineffective assistance.
It is, and he didn't develop it like he should. And if that is his number one trial strategy, which apparently he is very specific, again, in motion for new trial, because everyone's getting confused, and what are your strategies? Was it self-defense? Well, no, it was self-defense, but it was also that you can't prove the language in the indictment. Again, going away from the law of parties, that you don't have to put the law of parties jury instruction language into an indictment to still get a guilty verdict. But it's like he couldn't put that together. And so his ineffectiveness is coming up with this kind of half-done self-defense concept where he doesn't get his instruction, but that's his defense. But then his other defense is you don't see him doing the kicking and stuff, but if you're going to believe self-defense, then what part did he do to get you to the not kicking? It's just, it's this thing that doesn't make sense. I mean, it just doesn't. And even when he tried to explain it himself, it just doesn't make sense. And so that's one thing.
So if it is in fact the case that it was